You indicate that hindsight is 20/20, and you make many recommendations here, and you say that DCF has made some progress. But do you feel confident going forward there won't be another Harmony Montgomery case?
I think anyone who knows child welfare says that there's never a situation where we will know that a child will not be heard. There are very complex individual decisions that are made. However, we applaud DCF for robustly implementing our recommendations, and we will continue to work with them in monitoring compliance with those changes to ensure, as we review the data on what's going on at DCF, that there are not additional changes to those policies that are needed. We work very closely with DCF on their efforts at continuous quality improvement. And so I don't think anyone who works in this field can say there will never be another tragedy. But unfortunately, with every tragedy, we focus more on things that we recognize may have contributed to that tragedy.
What's your reaction? What's your reaction to what you've learned in this investigation? And are you outraged, like everyone else, that this young girl got caught in all this?
Obviously, we thought this case was important enough to engage in a full-scale multi-system investigation. What we believe is that Harmony's needs were not prioritized in the court hearings, and that there was inadequate presentation of both her medical, her emotional, and her educational needs. And by not focusing on those needs, that as you will read our full report, you will see that with the exception of the DCF attorneys, all of the other attorneys did not demand that there be an ICPC, did not object to Harmony being returned to a father who, frankly, had never had an overnight visit with her that we are aware of. Yeah, I am a bit concerned about the decisions that were made, a lot concerned about the decisions that were made in this case, but that's why our recommendations are focused on what we believe will make a difference in similar cases in the future.
What about a DCF attorney not presenting any evidence about what would be in her best interest for her to be safe and to thrive? I guess I'm struggling to understand why that would occur, and if there are any reforms or recommendations that would prevent that. Is there any justification that you found?
One of the challenges in this case that we talk about is the fact that there were many questions that we would have loved to have gotten the answers to, but the answers to those questions are covered by attorney-client privilege. Both what the client said to the attorney, the strategy that the attorney adopted as a result of those discussions, and the counseling that the attorney may have given to their client. The DCF attorney, we believe, was hampered by the inability to effectively assess Mr. Montgomery. We believe that that inability, that Mr. Montgomery contributed to that inability by not being cooperative in those times when he was in contact with DCF. That led to serious problems. DCF wanted the ICPC done, wanted that home study done because it felt correctly that had that ICPC done, there would have been updated information that only New Hampshire could have provided, because DCF social workers cannot cross state lines to do an investigation. That's why we have the ICPC. And DCF did argue as well as they could have not to continue without the ICPC. But in that court hearing, of which we have all, or the team that investigated, listened to the court tape, no other attorney, not Ms. Sori's attorney, not Harmony's attorney, certainly not Mr. Montgomery's attorney, objected to proceeding without the ICPC. So in that court hearing, only DCF presented information in opposition. We believe that stronger information could have been provided and wasn't provided, and that's why we've made the recommendation for an examination of the litigation strategy in these cases by DCF legal management.
Do you have any insight into why those attorneys did not argue more on her behalf? Just seems like they were just abdicating, they were just.
That is the challenge of this case. Unlike other cases that the OCA has investigated, where we were involved entirely with executive branch agencies over which we have full oversight. In this case, the constitutional barriers of attorney-client privilege means that we cannot ask questions about what was said or the strategy involved. So there are questions that, because of that privilege, remain unanswered.
It seems like many of the checks and balances
failed. And I wonder, in your career, what was the most shocking thing that you uncovered in this investigation?
That's a tough question. I will say the most shocking thing was what happened in the courtroom on February 19th. I was surprised that there was not more of a discussion of Harmony and Harmony's needs, especially given the history of the case. Father had not been actively engaged, even though he presented himself as having been rehabilitated. And as I mentioned earlier, we all applaud parents who address the deficiencies they had that caused a child to come into care in the first place. So it is there are lots of parents in this Commonwealth, some who are within the attention of DCF and some who have not, who may have criminal records. A lot of people do crazy things when they're teenagers, but that doesn't mean you can't be a good parent. The question here is, do you have the capacity to parent this particular child? And I will say that our investigative team was disappointed that there was not more of a discussion of Harmony's medical needs in particular, but also her needs for special education. I was surprised that there was not more robust cross-examination of Mr. Montgomery in terms of his self-presentation of his fitness. But if no one objects to what he is saying, leaves a judge very little choice in this matter.
Do you have any idea how long the court hearing was? The decisive court hearing?
I can't remember off the top of my head.
Was it longer than 2 hours or?
It adjourned for a while and then restarted, and that's why I can't remember how long it was.
Yes, ma'am.
So if we're looking at this as truly a systemic failure from social workers to attorneys to, the judge's decision in this case, are you confident right now that safety nets exist for the most vulnerable children in the Commonwealth?
I think that we have enhanced policies and procedures, that the OCA has been privileged to work very closely with DCF in the drafting of these policies and procedures. And they are really good policies and procedures. The
But are they
OCA
being
is now
followed?
working with DCF in a project to create risk assessment tools. These are complicated cases. Almost 82% of children who come to the attention of DCF in the fiscal year annual report are maintained at home, and with monitoring of DCF and with services and supports from DCF. That means you're not in someone's house 24 hours a day. And what we know is the vast number of the cases that DCF deals with are cases involving parents with substance use disorder and with mental health needs. What the Department of Public Health produced this year was data that indicated that a lot of people with substance use disorder relapsed as a result of the pandemic. We know that both in Massachusetts as well as nationally. So I think that we do the best that we can do to put policies and procedures in place that identify risk, that properly assess parents' skills and capacities. We try to provide the broad range of services that will help families stay intact. But there is no one who can say that everything is perfect in the system.
Do you think the legal standard for when children should be returned to their parents should be reviewed?
I will not say that it's the legal standard of sort of current unfitness and substantial harm. Our argument is that the standard for the representation of children, which is based on a either substituted judgment or direct representation, does not take into account the best interests of the child. And we have added in our report a survey by the American Bar Association that indicates that other states have adopted a hybrid or best interest standards. And we believe that if children's attorneys had to comply with that higher standard, then in the court hearing, there would be a presentation of what the child needs in order to be safe and to thrive. Some of those changes have already happened as a result of the changes that the juvenile court made in the bench book implementation coming out of Harmony. So questions about educational attainment and other things are now, weren't in place, unfortunately, in 2019, but now are in place as bench book guidance for juvenile court judges to ask.
What grade would you give the people that were handling Harmony Montgomery's case?
I don't want to grade individual people. The OCA focuses on what we believe is going to improve the system.
So what grade? I mean, not to pin you to it, but
I'm not going to go there.
well, approximately. What grade?
Well, will there be anyone involved in this facing any kind of disciplinary action?
That is outside of the jurisdiction of the Office of the Child Advocate.
Okay.
Do you believe there's a,
This investigation, DCF and DCYF in New Hampshire was on the front end of all of the scrutiny and all of the criticism. Your investigation seems to point to a failure further down the pipeline. And I'm wondering if it seems to you that Harmony was thrown away by the system.
I'm not sure that I would use those words exactly, but when we looked at this case, it was impossible to talk about what happened with Harmony without discussing what happened in the court hearing because of the change of custody. That was the kind of a key decision. There could have been better case management by DCF in this matter. We certainly were concerned that Harmony was 4.5 years old and had not yet achieved permanency, having entered state care at 2 months old. And that's something that everyone in the system owns, right? That this child had spent her entire life in foster care is one of the real serious issues here, because a child who enters care at 2 months old should be achieving permanency no later than 18 months. And here she was, 4.5 years later, with no permanent home and awaiting placement in an intensive foster care placement. And a child who, because of the instability of her life, as it has been reported, was experiencing behavioral challenges. So the issues here could not be addressed without talking about what happened in the courtroom.
Do you think there's a cultural problem beyond the systemic and structural issues you're pointing to with DCF?
What do you mean by the cultural problem?
Do you think there's a cultural
Do
problem?
I think there's a cultural problem? I think that there is always the hope that parents will rehabilitate themselves. That's what we want. The goal of child welfare is not to take children away from their parents. The goal is to help families remain intact. And our law, both federal law and Massachusetts law, set timelines in order to ensure that children don't languish in foster care and that they achieve permanency. So what we hope always is that a child will be able to go home. And there certainly current efforts are also to be applauded by the Department of Children and Families at the large number of children who are actually in kinship foster homes. So they're not with strangers, but are in the care of other family members, so that they can continue to be part of their family and grow up in those family environments. So I don't know that there's a culture. I think that one of our concerns is that children's attorneys do not appear to take a robust role in presenting the needs of the child, and that they are more likely to defer to what advocacy of the parents' attorneys rather than provide an independent advocacy, which is why we hope that the Committee for Public Counsel Services will take a hard look at their current standards.
So I'm wondering if the OCA would look into this or suggest that DCF then look into how many children are currently in foster care for a certain amount of extended time, if that's something that you would look at, and also how many children have been sent out of state without an ICPC.
We haven't addressed the second issue, but our recommendations do address looking at DCF of really looking at children who have been in care for a long time, where it does not appear that there is a sure path to permanency.
You haven't looked at it in depth, but do you have any sense if this case was an outlier that it didn't involve an ICPC over state lines, or that's a more common occurrence?
We have provided some data in the report about the ICPC process. I don't have data on that question.
You had mentioned earlier that New Hampshire case law had taken precedent over Massachusetts state law. Why was that if this was a Massachusetts law?
The judge, in issuing his custody order to Mr. Montgomery, articulated what they believed was a constitutional decision. And that decision that the judge made was that because the father was deemed to be currently fit, given the lack of other testimony at that February 19th hearing, that the judge concluded that by ruling that the father was currently fit, they could not then require an ICPC, because ICPCs under the New Hampshire case were not required unless the parent was unfit. Massachusetts case law would have held that because Mr. Montgomery had been declared unfit in an initial care and protection in 2015, that until the ICPC was completed, the ICPC would have provided information on the status of his fitness. Unfortunately, as we mentioned in our report, no one appealed that judge's decision. And the only people who can say whether that decision was correct, the judge's constitutional ruling was correct, are the Massachusetts appellate courts, either the appeals court or the Supreme Judicial Court, which is why we've also asked in our recommendation around DCF, excuse me, reviewing their litigation strategy of making it clear in which cases they will file an appeal in order to develop case law that clarifies some of these complex legal decisions.
How soon do you believe your recommendations have to be implemented, and how long will it take? Weeks or months or years?
I think these are going to be a little bit harder because they involve CPCS, over which the OCA has no statutory oversight authority. I think that what we found in the David Almond case is that the governor immediately committed all of his executive branch agencies to fully implementing all of the recommendations. And the juvenile court itself, as well as the Fall River Public Schools, all immediately committed. The report that we issued at the end of March indicates the progress of those recommendations. One of our recommendations here is that we all need to come together, all of the actors in the system, including key members of the legislature, to think about what do we want child welfare to be in Massachusetts in this current environment. And I think the current environment, and I would be remiss if we did not acknowledge, this is a really serious issue, that there is disproportionality in child welfare and child protective service systems. That poor families, families of color, immigrant families, are more likely to be reported to DCF. And there, although we have data that indicates that there's disproportionality at the front door, and that the aggregate data that we have from fiscal year 21 indicates that there is not an exacerbation of that discrimination once a case is opened at DCF, that these are really important issues in a period where we are really focusing on equity issues. So I think the leaders of the system need to come together and to have some serious policy discussions. And I think those policy discussions are likely to need a relatively, certainly not a very short period of time to come to an agreement about whether statutory changes and other major changes are needed in order to ensure equity of treatment and protection for children in the Commonwealth.
The governor has called for a guardian ad litem to represent all children that go before the courts in care and protection cases. Do you agree with that, and do you think it's realistic?
We definitely agree with that. If the Committee for Public Counsel Services is unwilling to change their standards to include the best interests of the child, then we believe, as we made the recommendation in the Almond case, that before a child is returned, that a guardian ad litem needs to be appointed in order to do the investigation, to ensure that there is, that the placement is a safe place for a child to be returned to. The governor's recommendation goes farther than the OCA's original recommendation in Almond, but we believe that guardian ad litems are needed. We understand that there has been concern about the number of people that might be available to perform the guardian ad litem function. Guardian ad litems do not only need to be attorneys, they can be qualified social workers. I believe that we can go out and recruit a group of individuals, they can be properly trained, and that we can have a cadre of guardian ad litems certified by the courts that also represent more equitable distribution of people's lived experience as GALs, ability to respect individual cultures, able to speak languages of families that they're investigating. So this, I believe, is another opportunity for us to do a better job for the children of the Commonwealth.
If you had the ability to ask that juvenile court judge who awarded custody to Almond Montgomery, New Hampshire, a question at the end of your investigation, what would you want to ask him?
That's an inappropriate question, so I'm sorry, I'm not going to be able to answer that.
Was there ever any consideration of keeping Harmony with any of her siblings, as far as you can tell, within either the social workers or her attorneys?
At the time that Harmony's custody was awarded to her father, she had a half brother. There was a half sibling. However, the law prefers custody to go to as full a blood relative as can be found. And in this case, what appeared to be a rehabilitated Adam Montgomery would have, under current law, both state and federal law, been the preferential placement for Harmony.
Have you taken any steps to educate the public on the importance of permanency?
The permanency, I think, is a legal concept that we focus on all the time. The OCA reviews cases every day of the week through both our complaint line, the critical report, and the cases of substantiated abuse in residential facilities and licensed child facilities that we oversee. We intervene in cases all the time, and we provide feedback to agencies and make recommendations on individual cases. The number of cases that we publicly release is much smaller than the number of cases that our staff deal with on a weekly basis. So on a daily basis, we are focused on permanency and raising a child when a child's case does not appear to be moving in a way is supportive of their well-being. And again, this becomes a serious constitutional challenge because parents under the law have the right to raise their children unless very substantial harm has occurred or substantial harm is imminent. So that's a pretty high threshold that needs to be met. And just to be clear, the Department of Children and Families does not take children into custody without a valid court order. So within 72 hours of DCF taking emergency custody, that decision needs to be ratified by a juvenile court judge in the Commonwealth of Massachusetts. And so DCF needs to be able to present enough evidence that shows substantial harm in order to maintain custody before the trial on the care and protection actually occurs.
A very boring clerical question here. So, has this been, how long has this case been under investigation? Was it prompted by Chief Justice Budd ordering it?
No, actually, the OCA, I would say, like the State Ethics Commission, reads newspapers. And so when we first saw this reported in the press and recognized, or the press indicated that there was a Massachusetts connection, the OCA quality assurance staff immediately pulled up the case and read the case. And we made an immediate decision that we needed to do a fuller investigation. So our investigation started probably within the first couple of days of the public press release. We didn't make that announcement as we pulled all of the documents that we wanted to review, but we were pretty quick in requesting both the court file and the court tapes. That is one advantage that the OCA has, which we have full access to individual cases in the juvenile court.
Who failed Harmony?
The system failed Harmony. That by not placing her needs at every decision point, at the decision points of continuing trying to return her to her home, to her mother's home, I think DCF really tried to support Ms. Sori in her trying to overcome her substance use disorder. And so they tried to give her multiple chances of being reconnected with Harmony. And I think that those decisions were made. And then shortly thereafter, I think there should have been a decision about a permanency plan for Harmony. At that point in time, Adam Montgomery was nowhere to be found. So we can't guess what would have happened. The what ifs don't count here. What counts are what actually happened. But if at every decision points about the foster care reviews, when decisions were made at the permanency planning conference about what was in Harmony's best interest, and then clearly in the representation by her attorney and the representation that happened in court, no one focused on Harmony, this beautiful little girl, and what she needed. There were medical concerns, there were behavioral concerns. She needed her special education. She had been in early intervention. For a child who was visually impaired, in order for her to understand the world, she needed all of these supports. And yet no one in that February 19th hearing said, how is she going to continue to get the medical support, the therapy that she needed? How is she going to continue in special education? It's just what she needed in order to be able to succeed in school and to understand her world. So it wasn't just one decision, it was a series of decisions that did not place her at the center and therefore made poor decisions about the risk that she was going to be facing.
Are there other Harmony Montgomerys out there that we don't know about today?
I hope not. If there are, we certainly get critical incident reports of the death, serious injury, and serious emotional injury of every child in the Commonwealth across every human service agency. And those are reviewed every single day. It's probably the first thing I do in the morning and the last thing I do every single night. And let me tell you, my staff will indicate where I call and say, I need this information right now. They're used to those late night calls or early morning calls. So we take the responsibility of oversight at the OCA incredibly seriously.
When she was placed multiple times back to Crystal Sorey and then removed again, was that because Sorey was suffering relapses or, yeah? Okay.
One of the issues that I think we need to address, should we be able to pull together this working group, is the complexity of relapse. We have our own data in Massachusetts at the Department of Public Health that indicates what the pattern of relapse is. And I believe that that information also needs to be taken into account both by our Department of Children and Families and by the juvenile court in making those decisions. Because relapse, when you are suffering some form of substance use disorder, the challenge here is, what do we know about relapse, about how it happens, the likelihood that you're going to relapse? How do we take that into account in terms of making the risk assessment for children? So this is one of those issues that definitely needs to be on the agenda. And I know that our own Department of Public Health has data that will help us figure this out.
In your assessment, is the threshold for removal, which is similar in New Hampshire as well, at the right place? That's a hard concept for the public to understand. People were shouting for, why wasn't she removed sooner? Things like that.
The threshold for removal really is a constitutional threshold, right? Because it has to be that high for the state to interfere with the parent-child relationship. So it's a constitutional decision that you have to prove either abuse has occurred or imminent serious abuse. And that's not going to change. I mean, that's built into the Constitution. I think what we can do a better job is in the analysis of the return home. And I want to be clear, because I don't want to be accused, as I expect I will be, that I'm interested in not returning children to their families. Nothing could be further than the truth. The OCA is actively involved in the redesign of family support and stabilization services so that we can ensure that families get what they need, so children don't have to come into care. But I think that given that so many of our cases involve substance use disorder, that I think that we need to do a better job of planning for that transition home. Imagine you have not had custody of your child or children. Let's say it's 3 children in 2 years. And you go from one day having no children in your house to having 3 children in your house. So that leisurely breakfast is now gone because you got to get lunch ready, you got to get 3 kids dressed, you got to get them out the door, okay? And oh, by the way, one of them's sick, so you're up half the night. So that transition home, according to child welfare specialists, I'm an attorney, not a social worker, but I rely on my clinicians. That return home is amongst the most challenging periods, and the most risk period is the return home. The Office of the Child Advocate wants to figure out how we can guarantee successful reunifications with no repeat maltreatment. That's the goal, right? And I think that we shouldn't be fighting with each other, and we should be focusing on what is it going to take for us to do whatever it takes to guarantee the successful reunification of children with their families. I ran an adoption agency before I became the Office of the Child Advocate, the Commonwealth's Child Advocate. And let me tell you, there was no happier day than my staff were able to get a child to achieve permanency. And we were able to get children achieving permanency at age 17. We had children with disabilities that I never thought would find a permanent home and that I feared would spend the rest of their life in care. And yet it happens every day. Social workers dedicate their lives to making sure the kids are safe and that they're with proper families. And in this Commonwealth, where we invest a lot of money in comparison to the other states that we deal with every single day, the other OCAs, we are very generous to the families in terms of the amount of money that we spend in support. So we need to sort of spend that money smartly and make sure that we're focused on the risks to children. So we don't have a situation where a year from now, I, as the child advocate, is presenting another investigation on a case that was not handled the way we wanted it to handle. Thank you.